I'm the Dean of the Law School. I want to welcome you here to one of our absolute favorite events, our Final Four. It's our 51st Final Four in our 100th year as a law school, and we are completely thrilled by the brilliant panel of four finalists that we have to share with you today. I think you'll agree they're dazzling, and I think it's going to be a great, great experience for all of us to get to hear them in action. Please join me in wishing them all an excellent experience. Oh, I was supposed to say, and Professor Moylan will take it from here.
Okay, thank you, Dean Schwartz. Welcome, everyone. So happy to see you all here. So excited for the advocates. I'm going to give you a very brief little what we're doing here, run of show, and then we're going to get right to the main attraction, which is the top oral advocate competition. So in your program, you will see there is a little bit of a background about this case. The students have been working on this case all semester, and the case started in the trial court with a criminal indictment of the client of our advocates for the defendant appellee. Unfortunately, our defendant was targeted by the U.S. government over here as a potential terrorist threat to the, a political attack on the Democratic National Convention was relayed in an anonymous tip. And we had motions to suppress. Some of them were denied, some of them were granted. Now we are on appeal in the Sixth Circuit Court of Appeal. Soon you'll be meeting our judges. Our panel for tonight, our chief judge is actually the chief judge of the United States District Court for the Eastern District of California, Judge Troy Nunley. He will be our chief. With him will be United States District Court Judge Dina Coggins. She also is a federal court judge for the Eastern District of California and a McGeorge grad who did moot court while she was a McGeorge student. So you might be on that end, some of you, and some of you in the near future. And our third judge is Judge Julie Wang Gutierrez. She is a judge of the Superior Court of California, and she used to be an adjunct who taught in our program before it was Global Lawyering Skills, when it was Appellate and International Advocacy, and is a McGeorge grad as well. And so you will hear the questions from the judges. We will hear the arguments of the advocates. After we do that, the judges will deliberate briefly. When they come back out, I will announce the winners of the Best Brief Awards. We have nominees here tonight, one nominee for each side from each section who wrote outstanding briefs. And I will remind you later of the value of the written advocacy as well as the oral advocacy. And we will award those, and then we will announce the top oral advocate winner, and then everyone will be invited to a reception where we shall celebrate and talk about evidence. So, because many of you tonight have an evidence final tomorrow, and I'm so sorry, but we're happy to talk about it with you. So, Professor Croxall is going to be our timekeeper for the evening. I am going to bring the judges out and we're going to get started, but I wanted to give you a little run of show so you know what to expect. Okay? All right. I think we're ready. He doesn't hear me. Let me go get him. Oh, he did hear me. He heard me.
Okay. All right.
Please be seated and come to order.
You may call the case.
All right.
Or I may call the case.
All right. I'm calling the case United States of America versus Justine George. Counsel, state your appearances. Let's start first with the United States government.
Cassandra Allen for the appellant.
Natalie Parker for the appellant.
All right, thank you, counsel. Please be seated. All right, and counsel for the defendant, Justine George.
Annalie Nguyen for Justine George, Your Honor.
All right, thank
Millie
you.
Hernandez for Justine George, Your Honor.
All right, thank you. All right, you may be seated. All right. And is the government ready to present your case?
We are, Your Honor.
All right, you may proceed.
Good evening, Your Honors. May it please the court. My name is Cassandra Allen, and together with co-counsel Ms. Natalie Parker, we represent the appellant, the United States of America. I will explain why the public safety exception was properly applied, and co-counsel will establish the confession was voluntary and the physical evidence lawfully obtained. May I please reserve 2 minutes for rebuttal?
Yes, you may.
This case is about public safety, police discretion, and preventing political extremism. The increased scale, scope, and sophistication of political attacks requires trained law enforcement to utilize discretion when confronted with individuals seeking to dismantle public safety. The United States respectfully requests that this court reverse the district court's order for 2 reasons. First, agents had a reasonable belief of an imminent threat to public safety. Second,
Counsel, can I ask you a question? So can you explain how the agents had an objectively reasonable belief that anyone was in danger?
yes, Your Honor, there are 2 factors that inform officers' reasonable belief. 1, the previous acts of political terrorism, and second, the corroborated tip, which provided agents a reasonable belief of an international terrorist threat. This circuit held in United States versus Williams that the critical inquiry is whether it is reasonable for officers to believe that a defendant might have or recently have had access to a weapon and inflict harm.
Does this court apply an objective reasonableness standard or subjective standard?
Your Honor, the public safety exception in this court is an objective standard, but this court also requires narrow questioning pursuant to that reasonable belief per the circuit's decision in United States versus Leicester. Turning back to the discussion about the reasonable belief, at page 11 of the record, the FBI headquarters had instructed officers that on previous occasions, political attacks and terrorist acts in battleground states, such as Michigan and Illinois, had previously included the use of bombs.
What circuit court rendered the Leicester decision?
The Sixth Circuit, Your Honor, the circuit. Additionally, at page 80 of the record, when agents received a tip alleging a political attack at the Democratic National Convention, where up to 50,000 people attend annually, agents could not rule out on this occasion that this political attack would include a bomb. This court further held in United States versus Hodge that when a bomb is believed to be the weapon at issue, bombs by their very nature are inherently unstable and support an officer's reasonable belief, even in absence that a defendant or a third party may have access to the weapon.
Counsel, does it matter, though, that here, for the public safety exception, the officers actually got it wrong, and Ms. George had no bomb or gun anywhere?
No, Your Honor. In New York versus Quarles, the Supreme Court held that the application of the public safety exception should not depend on post hoc findings. Instead, it should be focused on a reasonableness on the ground. Turning to the discussion about the corroboration of the tip itself. The agents corroborated this tip pursuant to the standard by the Supreme Court in Florida v. JL. Anonymous tips may be sufficiently relied upon when they demonstrate sufficient indicia of reliability.
Let me ask, was the tip reliable? Who was the signatory on the tip?
Your Honor, the tip at page 80 of the record alleged that Dumbledore's army would be the individual involved. However, this could be a pseudonym and agents could not rule it out.
What was the letterhead? What was it? Where was it coming from?
It was a platform 9 3/4 stationary, but agents still had to be extra.
And what is? Do you understand what that's a reference to?
Harry Potter, Your Honor.
And you found that to be reliable?
Your Honor, what the agents found reliable was the totality of the circumstances pursuant to the tip. In Illinois v. Gates, the totality of the factors alleged may be taken into account. In this case, defendant matched all 9 characteristics alleged in the tip. On August 15th, a white, non-English speaking female would be driving on the Interstate 75 towards Chicago with Canadian plates, and all 9 tips matched. For these reasons, agents at this point can sufficiently link defendant to this tip. However, Alabama v. White, the Supreme Court further held that once a tip has been suitably corroborated, it has future predictive reliability. So once they had linked the defendant to this particular tip as being the individual in question, agents could then continue their investigation.
Counsel, let me back up a bit here. What standard of review would you have this court use in deciding whether the district court's decision was correct?
Your Honor, this court in United States v. Williams said that the public safety exception should be reviewed de novo.
And what does that mean, counsel?
From the beginning, from anew. In this case, you have the purview to review it as if it was the first time that the court has seen it.
And what factors would you have the court focus on in this particular case then?
I would focus, Your Honor, on the reasonableness in the moment with what agents had access to, in particular that spontaneity is the order of the day and not rigid adherence to a police manual, as is the focus of the public safety exception. Turning now to my second point.
Isn't the public safety exception extremely narrow?
Under the circuit, Your Honor, yes, but let's focus on those narrow questionings that is the actual substance of the public safety exception. All 5 questions agents asked were narrowly tailored to clarify the scope and nature of the threat posed. This circuit in United States v. Lester said that a narrow question is such that stems from specific evidence that a defendant could inflict harm. All 5 questions were narrowly tailored. The first question found at page 12 and 13 of the record is whether a defendant could produce driver's license and identification. In United States v. Williams, this circuit allowed agents to ask whether a defendant had such identification because it allowed agents to understand with whom they were dealing with and whether this individual had previous criminal activities.
Counsel, could you remind the court, in Lester, was the defendant Mirandized?
Yes, Your Honor, she was.
Okay.
And also, you mentioned earlier in response to my colleague's question that the cases seem to suggest that the public safety exception is a narrow exception. Why should that be the policy?
Your Honor, the public safety exception is a careful balance between a defendant's right against self-incrimination and the reality that agents need some measure on the ground to protect public safety, and this case fits within that narrow exception. Turning now to the other questions asked by agents. At page 23 of the record, agents asked where she was going. In United States v. Abdul Muntab, this circuit affirmed the Eastern District of Michigan's application of the public safety exception when they allowed, quote, officers to ask about where a defendant had traveled, with whom they were traveling with, and where they were going.
So let me ask you this. You stated that this court is to apply a de novo standard of review, and if that is the case, then, as I look at the record, it does not appear that the agents were actually fearful or concerned about any exigency. So if we were to apply the public safety doctrine here, wouldn't that broadly expand the scope of the public safety doctrine to non-exigent circumstances?
No, Your Honor. The United States Supreme Court held in New York v. Quarles that the exception defines the exigent questioning. The Second Circuit, which follows similar narrow reasoning to this circuit in United States v. Khalil, allowed agents to ask a, quote, broader question that nonetheless encompassed public safety when they asked a defendant what their intention was. Likewise, agents did so at page 35 of the record when they asked what her activity was engaged with, because such questions allowed agents to understand the purpose of the threat or the attack that defendant was alleging at page 80 of the record. The fourth question found at page 69 of the record is whether the defendant had a bomb or other explosive. The Second Circuit in United States v. Reyes allowed an investigating officer to draw on their knowledge about the tools of the trade, quote, and what a suspect might have on them.
What were the facts of Reyes?
Your Honor, the facts of Reyes, this was a drug case, and in that case, agents knew that many drug dealers use bombs or needles on their person. However, this case, the tools of the trade, as instructed to officers at page 11 of the record, political attacks have previously included bombs, and that's why they asked a question about where is the bomb or other explosive. And at page 22 of the record, Agent Suarez stated that she believed that the car itself was a bomb, and that demonstrates that that belief was reasonable pursuant to that background.
Well, counsel, let me interrupt you. Does it make sense to use an objective standard versus a subjective standard, and if so, why?
Your Honor, an objective standard is important because it allows the court to reasonably balance those needs for defendants in that moment and agents on the ground. However, objective situation based on the facts on the ground about the nature of the threat, what's actually happening and unfolding, allows the court to focus its attention on readily reviewable facts as opposed to subjective intentions, which at the appellate level, we would not have access to. That fifth question at page 69 of the record is whether the bomb was in the car specifically. This circuit in United States versus Talley allowed officers to ask, where is the gun? Because they need to understand where the threat is located. Likewise, agents did so here. They needed to understand, was the bomb in fact in the car?
Is there any evidence in the record to suggest that someone other than the police might gain access to the alleged weapon?
Yes, Your Honor. At page 9, when defendant approached the home, they found that defendant was not alone and with third parties. This circuit in reviewing terrorism in the United States, Your Honor, I see that I'm out of time. May I briefly respond to your question
Yes,
and
please
conclude?
finish.
In United States versus Abdul Mantab, they noted that when terrorism is involved, these individuals tend to work in larger groups, and so when agents found her with another individual at the home, they could not rule out that there was a conspiracy with other individuals on this occasion. In conclusion, justice requires a careful balance between a defendant's right against self-incrimination and the reality that agents need some measure on the ground to protect public safety. Justice will not be applied if this discretion is not afforded to them in this case. For these reasons, the United States respectfully requests that this court reverse. Thank you.
Thank you, counsel. Thank you.
Good evening, Your Honors. May it please the Court, Natalie Parker on behalf of the government. I will be arguing the issue of coercion and the improper suppression of physical evidence. The district court erred when it allowed the physical evidence to be suppressed for the following two reasons. The first reason being that the defendant's confession was voluntary, and the second reason being that via the doctrine of inevitable discovery, suppression of the physical evidence was improper.
Counsel, do we need to give deference to the district court's determination that the confession was involuntary?
Certainly, Your Honor. Specifically, the district court's ruling in regarding the the confession being involuntary, the district court relied on a Seventh Circuit opinion, specifically U.S. v. Law. And in that circuit even, the court held that voluntariness cannot specifically only be attributed to whether or not a defendant has personal characteristics that would render certain tactics used by law enforcement agents to be more coercive than someone else. In that case, the defendant had been trafficking heroin and came from a country where tactics that we would regard as being objectively coercive, such as physical violence, psychological intimidation, being something that's standard. However, the Seventh Circuit court held that those characteristics specific to that defendant cannot be taken into consideration as the only basis for finding a finding of coercion.
And my question is, should we give that deference, that decision deference, this court?
The Sixth Circuit has a test itself, the McCall v. Dutton case, in addition to the Supreme Court case, U.S. v. Mahan, to determine whether or not coercion was at hand in a particular case. Even so, giving deference to the case that the district court relied on in this case, the specific personal characteristics of the defendant in this case do not give rise alone to coercion. Even more so, in the case of U.S. v. Law, the defendant, as I mentioned, came from a country where he knew he would be subjected to actual coercion if he had been stopped by the police, which is why he felt coerced, even though he hadn't been subjected to any coercive activity by the police officers in that case. Here, the defendant is from Canada. In no way, shape, or form should she have had any expectation that she would be subjected to any level of political violence just because she had been stopped by the police. More so, she was a college-educated, university-educated individual. Therefore, she wasn't going to be expecting any kind of coercion in relation to the way that the defendant...
Well, how should we evaluate whether or not the agents engaged in coercion in terms of their whole attitude towards it? How should we judge that?
In McCall v. Dutton, the Sixth Circuit articulated a three-pronged test in order to evaluate whether or not coercion has been at play. Specifically, the first prong of that test is a threshold test, and that is that the police activity needs to be objectively coercive. Here, that just wasn't the case. The agents in no way, shape, or form psychologically intimidated the defendant. They did not subject her to any kind of physical violence. She was not...
It doesn't have to be physical, right? Didn't she, on at least 2 occasions, request either to speak with the consulate or with an attorney, and the agents did not allow her to do that? In fact, I think that they even made statements to the effect of, not until you answer our questions.
Yes, Your Honor, that
Is
can
that
be...
not coercive?
Yes, Your Honor, that can be taken into consideration when evaluating in this three-pronged test. However, that alone is not sufficient to give rise to a finding of coercion, especially because the defendant was not outright denied any access to counsel at any point in time. In fact, counsel had been contacted on her behalf. In the district court's ruling
Did
regarding...
she know that counsel had been contacted?
She didn't know that, but counsel was on the way and counsel had been contacted. And although she wasn't aware of that, she was in some way, shape, or form aware of her rights to counsel, which is evidenced by the fact that she did ask. Again, that isn't the only factor that should be taken into consideration when determining whether or not a defendant was coerced, especially when taking into consideration that there is a three-pronged test.
Well, then, give me your best argument as to why the agents did not engage in coercion. Give me your best argument.
She volunteered all of the information that she gave to them. She was not held incommunicado. She was in no way, shape, or form isolated from her surroundings. She was questioned openly in her friend's house. Her friend was there at the time of the questioning. She was never handcuffed. She was never told that she needed to confess, otherwise she would be subjected to any kind of adverse effects. She was advised that she could be subject to arrest or immediate deportation if there was a finding that she was involved in criminal activity. However, a simple advisement of the stature of someone's involvement in criminal activity is not sufficient to give rise to coercion itself. In U.S. v. Ramadan, the court held that when a defendant is told that they will be intentionally deported to a country where they've been persecuted and suffered political violence does give rise to coercion in and of itself. But a simple advisement that she could be deported or arrested because she was involved in criminal activity does not give rise to that same level of coercion that was found.
I'm sorry, what is the difference? I'm not sure I picked up on the distinction there.
The distinction here is that in U.S. v. Ramadan, the defendant had been relocated to the United States because he had previously cooperated with the U.S. military, which had resulted not only in threats of violence and persecution for him, but he had other family members that had suffered from political persecution in Afghanistan. As opposed to here, where the defendant was simply advised that she could be arrested and deported, as opposed to in U.S. v. Ramadan, he was promised that he would suffer that political violence that he was aware of, that his family members had also suffered from if he didn't confess.
Okay.
Here, the defendant was not told that if she failed to confess, she would be deported or arrested. Simply if there was a finding that she had been involved in any kind of criminal activity, she could be arrested or deported. Similar to the holding in Schneckloth v. Bustamante, the Supreme Court also held that simple advisements of whether or not a defendant could be subject to arrest or deportation because of their involvement in criminal activity, that alone is not sufficient to a finding of coercion. It's simply a truthful statement about what can happen if there is a finding that there is engagement in criminal activity.
Well, on the issue of coercion, should we give more weight to the agent's perception, in this case, Ms. George's perception, or equally?
Could you rephrase your question?
In assessing coercion, should we give more weight to the agent's perception of whether it was coercive, Ms. George's perception, or both equally?
Both can be assessed. Specifically, though, the defendant's perception of what's going on is not the only thing that gives rise to coercion. Again, in McCall v. Dutton, the defendant's own perception cannot be the only thing that a court relies on in order to find that there is coercion, especially because in New York v. Quarles, the Supreme Court articulated that there is objective and presumptions of coercion when a defendant is being interrogated. So that alone is not enough to give rise to a finding of coercion. When a defendant is faced with interrogation and an awareness and advisement that they could be subject to criminal prosecution, there is an expectation that a defendant may feel fear. But that alone is not enough to give a finding of coercion. To my second point in regard to the three-pronged test in McCall v. Dutton, the coercion in question needs to be sufficient to overbear a defendant's will. Again, that wasn't the case here. The only allegations of coercion that the defendant alleges are simply not enough to find that the police or the agents in this case were completely coercive. The defendant, as I mentioned, was university educated, and that alone gives rise to the belief that she just wasn't ignorantly in this situation, bogged down by police coercion. Defense relies...
Why can we assume that?
Why can we assume that?
If you're college educated, you wouldn't have a feeling of being coerced.
Just being university educated is not sufficient to find that a defendant wasn't coerced, but it is a factor in considering whether or not a defendant was coerced. In Colorado v. Connolly, the Supreme Court held that neither mere emotionalism and confusion nor mere trickery will alone necessarily invalidate a confession. Therefore, here, given the fact that she was university educated and she was approaching this situation as someone who isn't just an ignorant individual on the street with no awareness of any of the legal proceedings or legal processes around her, she's not been coerced. And to my last point in regard to coercion, the police misconduct needs to be the crucial motivating factor in the defendant's decision to confess. Here again, that wasn't the case. The defendant was advised that if the political attack did happen at the DNC and lives were lost, those lives lost would be on her conscience. And that seems to be the main factor in what led to her being more voluntary with her confession and deciding to confess. However, that is not coercion. The fact that she felt guilt that maybe if there was a political attack and she didn't tell them that she was engaged in this criminal conduct, that doesn't equate to coercion.
If we find that the officers did engage in coercion, why should we also suppress the evidence?
Even if there is a finding that her confession was involuntary, the case law does not support a suppression of the physical evidence, specifically because there was probable cause independent of the confession that the defendant offered. In Illinois v. Gates, the Supreme Court held that when a tip is sufficiently corroborated through an independent investigation, it gives rise to probable cause. Therefore, even if the defendant's confession is out, the agents would have been able to get a search warrant and they would have been able to search the defendant's car and they would have found the LSD.
So what's the corroboration here?
The corroboration is the independent investigation, specifically the checkpoint that was set up along I-75. The agents operated this checkpoint for 10 and a half hours and stopped multiple individuals. And again, as my co-counsel mentioned, the main point that needs to be met in regards to whether or not a tip has been sufficiently corroborated is its ability to predict the future behavior of a defendant. In both Illinois v. Gates and Alabama v. White, the anonymous tips and anonymous phone calls sufficiently and properly predicted the future behavior of the defendant, which gave rise to the reliability. Similar to here, not only did the defendant match all of the components of the tip, but specifically that crucial factor of the predictive behavior was met here as well. The defendant was traveling to Chicago, which was the main point in the tip that needed to be corroborated to give rise to its reliability. Therefore, having sufficiently corroborated that piece of the tip, the agents were properly proceeded with their investigation, in addition to the fact that the physical evidence would not be properly suppressed, even if the confession is out.
Counsel, how should we evaluate whether the inevitable discovery or independent source doctrine applies in this case? What standard of review should we use there, counsel?
De novo, again, in the entirety of this case, this is a mixed question of fact and law. In U.S. v. Talley, the Sixth Circuit held that those kinds of questions should be reviewed de novo.
Let me ask you this. Didn't the agents rely on Miss George's confession in order to justify the search of the car and the house?
In this instance, yes, but that's not the main motivating factor that should be considered by the court in regard to whether or not there was probable cause.
But how can this court apply the inevitable discovery or independent source doctrine here if in fact the agents did rely on her confession?
I see my time has expired, but may I
Yes,
answer the
please.
question? The probable cause component of this is completely independent of the confession. Again, as I was articulating, if the confession is out, there was that probable cause component. Therefore, independent of whether or not the defendant had chosen to confess, there would have been probable cause to get a warrant. Therefore, they would have gotten into the trunk regardless, and she would have, again, still been arrested for the possession of the LSD.
Okay. Thank you, counsel.
Thank you.
Thank you.
All right, counsel for Ms. George, you ready to proceed?
Yes, Your Honor.
All right, you may proceed.
Good evening, Your Honors, and may it please the court. My name is Annalie Nguyen, and tonight I'm here on behalf of Miss Justine George. Tonight I will be handling the public safety exception issue, and my co-counsel, Ms. Hernandez, will be handling the voluntariness issue. This case is about law enforcement deliberately ignoring an individual's constitutional rights to further their investigation rather than to alleviate any emergency.
Well, counsel, I'm going to stop you right there. You know, in reading the Quarles decision, doesn't Quarles tell us to judge or to trust the decisions that the agents are making on the ground and not to second guess the decisions that they're making in the field?
No, Your Honor. In New York versus Quarles, the court says that officers may ask questions necessary to secure their safety or the safety of the public. However, in New York versus Quarles, it also says that if there are any beliefs that there is no immediacy, then public safety exception does not apply. In this case, in this jurisdiction, we apply a objective standard as demonstrated in United States versus Talley, and that objective standard says to look at all reasonable articulable facts. Going to my first point.
Well, can you close that loop? What are the facts here then that show that there's no immediacy?
Yes, Your Honor. When we look at the agent's conduct throughout the interrogation, they stopped Ms. George at 2:23 p.m. on I-75, and rather than questioning her there, they allowed her to continue on to a place at that point they did not know. And when they followed her, they saw that she was going into a residential area, and at that point, they did not stop her to question her about whether there was a bomb in her car or whether she had a bomb at all. They allowed her to go into the home, go out of sight for over 30 minutes, and then approach. Within that period of time, they contacted headquarters, but not once did they mention any bomb threat, any weapon, or anything else. And once they did go into the house, as demonstrated on page 67 of the record, the agents only got closer and closer to both Ms. Osmond and Ms. George. And this demonstrates that the agents had no imminent fear for their safety throughout the interrogation.
What questions did the agents ask, Ms. George?
Your Honor, most of the questions that the agents asked focused on probing for testimonial evidence. One of the questions that opposing counsel did not mention is that the agents asked, "What is your criminal enterprise?" And this is demonstrated on page 28 of the record. The agents actually pressed this question multiple times, and it wasn't until later, until maybe the middle of the interrogation, that the agents asked whether there was a bomb in her SUV. So for the majority of the interrogation, they focused on probing for testimonial evidence.
Are those questions permitted under the public safety exception?
No, Your Honor. As demonstrated in United States versus Brathwaite, agents are not allowed to ask any questions they wish or to just probe for testimonial evidence. And while this is a Fifth Circuit case that the lower court applied, it is harmless error here because even if the court applied Sixth Circuit cases such as United States versus Leicester, the result would have been the same because the core of those cases is New York versus Quarles. In Quarles, the officer asked, "Where is the gun?" And this was appropriate under the exception because the court found that there was an immediate necessity to find where the gun was. Similarly, in United States versus Leicester, this court found that the officer's question of whether there was anything that could stick or harm the officer was appropriate because at the time, the officer had already found crack cocaine on Lester's body, and it was reasonable for the officer to believe that there may have been something else to harm him. Turning back to my first point, the lower court was correct in concluding that the agent's questions went beyond the scope. As I previously mentioned, the public safety exception does not allow for testimonial evidence, but here that is where the agents focused on. Rather than asking where is the bomb from the start, they focused on what is your criminal enterprise. And when we look at the tip itself—
Why is that significant?
Your Honor, it's significant because the only answer to that question is a testimonial answer. And under the public safety exception, the agents do not have to give a Miranda warning if it's non-testimonial questions. However, because they were testimonial, the agent should have stopped, gave her Miranda warnings, allowed her to speak with counsel, brought her into an interrogation room, and then asked the testimonial questions. However, that is not what they did here. And on the basis that they believed that there was a bomb, that was not based on fact, but rather on assumption. When we look at page 11 of the record, that FBI memorandum dated May 1st of 2024 only states that there had been an increase in bomb threats and an increase in mass shooting threats. However, when we look at page 80 of the record, that vague tip that the agents relied on for their checkpoint never mentions any weapon, violence, let alone a bomb. It simply states that there would be a white woman driving a dark-colored North American-made SUV who does not speak English and with Canadian license plates. But even when considering all these characteristics together, this is not enough because as compared to Alabama versus White—
Well, didn't she fit the description?
Yes, Your Honor. While Ms. George did fit the description of these vague characteristics, it's important for the court to consider how broad each characteristic was. For example, when looking at the Canadian license plate, when considering our proximity to the Canadian border, it's not rare to see that there would be Canadian license plates. Further,
So you would concede then that the officers, at least based upon based upon your client fitting that somewhat vague description, that they at least had a right to stop her and question her?
Your Honor,
correct?
that is correct. However, the agents did not stop anyone else after Ms. George, so just because she matched some of the characteristics within this tip does not mean that that tip was specifically about Ms. George. There was no one else that the agents stopped after Ms. George, so this court and everyone else will not know whether there was anyone else that may have actually matched to the T that tip, that someone else was actually going to the Democratic Convention.
Well, you would agree then that the officers stopped her based upon sort of an objective standard, correct? And don't you think it's important that the officers operate on an objective standard rather than a subjective standard?
Yes, Your Honor. According to United States versus Talley, the agents should be operating on an objective standard. However, the belief that the agents said is that they believe that there was a bomb present. However, nothing on the record supports this. Turning to my second point, there was no immediate threat. Here, when we look at United States versus Williams, this court created a two-part inquiry when determining whether an agent's belief is reasonable. First, whether the defendant recently had or has a weapon, and second, whether someone other than the police can gain access to that weapon.
Yeah, but does that really matter? Does it really matter to the public safety exception whether, the officers got it wrong and she didn't have a gun, nor did she have a bomb on her? Does it really matter to the exception itself, given the objective standard that you talked about?
Your Honor, the result may not matter. However, it matters that in the moment, there was no immediacy concern, and that is what is important. Because under the public safety exception, there needed to be an actual immediacy concern that the agents believed in on an objective standard for them to use the public safety exception. However,
What are some examples in case law about immediacy?
For example, this court has used United States versus Bell, where an officer had locked an inmate in a holding cell, and when they came back, the inmate was not in the room, and he descended from the ceiling. And because the officers had not known where the inmate had gone, the public safety exception was applied just in case the inmate had gone to grab a weapon. Secondly, in United States versus Hodge, the public safety exception applied because the officers believed that there was a bomb present. However, although
Isn't that the case here?
No, Your Honor. In that case, there was actually enough information for the officers to believe that there was a bomb, that to the point that when they got to the house, they had bomb specialists with them. However, in this case, that is not the case. Despite claiming that they believed that there was a bomb present, they never once contacted headquarters to ask for bomb specialists to come on site to help them locate this bomb or determine where this bomb was. Instead, they focused on asking testimonial questions about her criminal enterprise as a whole.
Doesn't the grant of the motion to suppress really unduly burden law enforcement's ability to protect us?
Your Honor, while the public safety exception allows for some leeway for officers and law enforcement to consider their circumstances around them, in this case, the objective standard is that whether there was actually immediacy that the agents believed, and through their conduct, there is no demonstration that there was an immediate concern. As we see, they stopped Ms. George at 2:23, and there wasn't a confession until approximately 3 hours later, around 5:30 p.m. Within that 3-hour period, the agents never stopped and actually searched that car that they claimed they believed there was a bomb. They never stopped to ask her clearly, do you have a bomb, to have SWAT come in to stop her and actually question her. There was none of that conduct. Turning back to my second point, in United States versus Hodge, that case is distinguishable from this case because in that case there was specific information, and there was specific information that allowed the officers to go in and locate that bomb. And while opposing counsel cites United States versus Abdullah, that case is also distinguishable from this case. In that case, there was a known self-proclaimed terrorist that was a part of the Al-Qaeda group. Al-Qaeda is a connected organization with terrorist activities. However, in this case, there is no information, nothing on the record that supports that Ms. George was at all connected to any terrorist activities. The tip simply states that there would be a political attack. However, the word attack in itself does not mean any violence. When we look at different dictionaries, such as Merriam-Webster, the dictionaries define attack as actually two things colliding, two things going against each other, and that in itself does not mean violence.
The facts state that the agents used good cop, bad cop tactics, and they actually threatened her with deportation. Does that matter to the potential application of the public safety doctrine?
Your Honor, that would go to the voluntariness aspect, but to answer your question, whether the agents use bad cop, good cop, will go towards whether Ms. George actually believed she was in a coercive state, which my co-counsel will tell you more. Therefore, this court should affirm the lower court's decision based on the fact that the agent's questions went beyond the scope and there was no immediate threat. This court should affirm the lower court's decision because if it does not, it will be creating precedent that allows law enforcement to go beyond the scope of the public safety exception and go against people's constitutional rights. Thank you.
Thank you.
Thank you. All right, counsel, you ready to proceed? All right, you may proceed.
Good evening, Your Honors, and may it please the Court. My name is Millie Hernandez, and I am here on behalf of Ms. Justine George. I will be speaking in regards to Ms. George's involuntary confession and why the inevitable discovery exception does not apply. Your Honors, this case is about protecting individuals from coercive conduct by law enforcement as the core tenet of the Fifth Amendment demand. In the limited circumstances where this Court has recognized exceptions, it has done so narrowly. Ms. George respectfully requests that this Court affirm the District Court's judgment for the following two reasons. First, the agent's misconduct led to Ms. George's involuntary confession, and any subsequent evidence discovered is tainted fruit. And second, the inevitable discovery exception does not apply because agents would not have acquired the evidence lawfully. Turning to my first point.
Counsel, before we get to your first point, does this court need to give deference to the lower court, to the district court's conclusion that the confession in this case was involuntary?
No, Your Honor, the standard of review is de novo, so you would be reviewing it from the beginning to the end, as stated in United States v. Rigsby. In United States v. Rice, this court held that when a defendant asserts that their confession was coerced, the government must prove by a preponderance of the evidence that the confession was voluntary. Therefore, the United States must demonstrate that the totality of the circumstances surrounding Ms. George's confession did not overbear her will, and that the confession was a product of her free and rational choice. They failed to meet that burden here. In McCall v. Dutton, this court examines three factors that deem a confession involuntary. First, the police activity had to be objectively coercive. Second, the coercion had to be sufficient to overbear the will of the defendant. And lastly, the coercion had to be the crucial motivating factor in the defendant's decision to confess.
Well, so the third, I'm sorry, on the third element there, it appears that there was the defendant, Ms. George, she voluntarily confessed to protect Ms. Osman and to discontinue the questioning. So that seems voluntary right there, so.
No, Your Honor. Although Ms. George did not confess to protect Ms. Osman. She was at Ms. Osman's home, but she confessed because of the threats that the agents were making to her and Ms. Osman.
What were those threats?
On page 68 of the record, Agent Johnson testifies that he and Agent Suarez engaged in good cop, bad cop tactics in order to apply psychological threats. They threatened not only to deport Ms. George, but also to deport everyone she was associated with, and told her that if people died, it would be on her conscience forever. In United States v. Finch, this court held that when threats are made that are not legally supported, they can deem a confession involuntary. In Finch, the detective had entered the home and told the defendant that they would arrest his mother and his sister if he did not cooperate. And this court held that at that time, those agents had no legal basis to make such threats. Similar to our case, when agents threatened to deport Ms. George and Ms. Osmond, they had no legal basis to do so, as they could not even arrest the women at that time.
Were they threatening them, or were they advising them of consequences?
Co-counsel mentions that they advised them, but on page 68 of the record, Ms. Osmond testifies that they threatened to deport Ms. George or deport everyone she was associated with unless she confessed, unless she confessed. In Haynes versus Washington, the Supreme Court held that a confession was involuntary when the defendant was not allowed to speak to his wife or his attorney unless he cooperated. Similar to this case, on page 39 of the record, Agent Johnson testifies that although Ms. George asked multiple times if she could either end the interrogation or if she could wait until her attorney arrived, and yet Agent Johnson did not tell her she could have these things if she cooperated. He told her she could have these things once she confessed.
Well, counsel, the fact that the officers, the FBI, was investigating a terrorist plot, doesn't that give them leave to apply some level of coercion, given the gravity of the plot?
Your Honor, in regards to the questions that they could have asked her, they could have still approached it in a different manner because they didn't have any legal basis for truly believing that Ms. George was the defendant that they believed. In United States versus Brown, this court examines the totality of the circumstances surrounding a confession in order to deem it involuntary. And that test includes both the characteristics of the accused and the details of the interrogation in order to determine their psychological pressures on the ability of the defendant to confess.
Counsel, I need to go back a moment. Where in the record did the agents threaten immediate arrest or deportation I thought it was that if she did not answer their questions, but not what you just stated?
On page 68 of the record, it's for Ms. Osmond's testimony, Your Honor.
Okay, thank you.
And what does that state? What does that indicate?
This is Ms. Osmond's testimony to saying that when she was threatened with deportation, they threatened to deport everyone she was associated with, and if innocent people lied, it would be on her conscience, Your Honor. Going back to the totality of the circumstance test, that test includes the details of the interrogation and the characteristics of the accused. On page 55 of the record, it reveals that Ms. George was a foreign national who did not speak English and became a primary suspect merely because of her physical appearance and the vehicle she drove. On page 13 of the record, after Ms. Osmond had been silent for over 15 minutes, agents decided to engage in these psychological pressures in order to get her to cooperate. And their specific misconduct is reflected on page 25 of the record when they did not Mirandize Ms. George, on page 26 of the record when they lied to her about her ability to contact the consulate, on page 27 of the record when she asked to speak to her attorney and they denied her her constitutional right to do so, and on page 58 of the record when she asked to end the interrogation and they did not let her to do so.
Let me ask counsel, you were here when I asked the questions to opposing counsel about this college education and having been at a university. How, if at all, does that matter in our assessment of this case?
Your Honor, they do fall within factors in the totality of the circumstances test stated in Brown, but they're not determinative in regards to outweighing the agent's actions and the fact that they not only made these threats and psychological pressures, but they also violated her constitutional rights in doing so. And because of that, it led to her involuntary confession, and they satisfied all three of the McCall factors. And the United States has to demonstrate that these same factors all led to a voluntary confession, and that her will was not overborne, and she made this decision out of a free and rational choice, which they failed to do so, and they failed to do it by preponderance of the evidence. Furthermore, in a plurality decision by the Supreme Court in United States versus Patain, the Supreme Court held that any individuals that are subjected to coercive interrogations are protected from the use of those statements and any subsequent evidence discovered in any subsequent criminal trials. Therefore,
What were the facts of that case?
in Patain, they were about to Mirandize him, but he said, yeah, I know my rights. And so they didn't finish Mirandizing him, and therefore it was not allowed to. They weren't allowed to because he cut off the Miranda rights. So the court held that he was not Mirandized. Because Ms. George's confession was gathered involuntary, any subsequent evidence is therefore fruit of the poisonous tree. Moving to my second point, the inevitable discovery exception does not apply in this case. In order for this exception to apply, this court has held in United States v. Kennedy that the government is required to prove by a preponderance of the evidence that they would have acquired such evidence lawfully. An opposing counsel asserts that they would have been able to obtain a search warrant via probable cause. However, agents would have lacked sufficient probable cause using the same case of Illinois v. Gates. In Gates, the Supreme Court had an anonymous tip that had extreme details. It said the who, the what, the when, and the how. Mr. and Mrs. Gates were engaged in criminal activity, told us where they lived. It said that Miss Gates was going to drive on a particular day to a particular hotel, and Mr. Lance would fly in and meet her at that hotel, and they would drive together, and it specifically said that the drugs would be found in the trunk of the car, and that when they got to the home, the officers could expect to find the drugs in the basement of the home. And yet the
Isn't that
Supreme
what
Court...
happened here? It was a specific date. She was going to be going to a specific location, driving a specific vehicle. So how was that different?
Your Honor, Ms. George didn't go to the specific location deemed on the tip. She went to her friend's house in Grand Rapids, which was over 200 miles away from Chicago. And so in Gates, where the Supreme Court held that the agents had to corroborate the key elements that predicted the nature of the legal activity, agents failed to do so here. The key component was that this person should be arriving at this location that was of risk, and Ms. George was not there. She was on a highway and 200 miles away from that location. Additionally, in United States v. Helton, this court held that an anonymous tip demands a more stringent scrutiny regarding its veracity, reliability, and basis of knowledge. And most importantly, it has to be reliable in its assertion of illegality and not just its tendency to identify a person. The truth is, this anonymous tip on page 80 of the record states only innocent characteristics about a white woman driving a dark-colored SUV with Canadian license plates. And it did nothing to link Ms. George to this criminal activity, and it certainly didn't provide any reliability that agents could actually find weaponry or explosives in her vehicle, let alone give them any probable cause to enter the home. In conclusion, Your Honors, this court has consistently committed to upholding the fundamental values of the Fifth Amendment, and governmental abuse is simply not one of them. For the foregoing reasons, we respectfully request that this court affirm the district court's judgment. Thank you.
Thank you. All right, 2 minutes for rebuttal. You may proceed.
On rebuttal, Your Honors, I'd like to address 2 points. One, opposing counsel misstates which indicia are given extra weight by courts when reviewing anonymous tips. Second, opposing counsel misstates the unlawful actions by the police. Unlawful statements are those that have no legal basis. However, truthful statements related to a defendant's predicament are not the type of statements to render a confession involuntary. Turning to the first point, the Supreme Court held in Alabama v. White that particular emphasis is given on indicia related to tips, information known to only small groups of individuals, such as itinerary information. 4 of the 9 characteristics are related to itinerary, that she's going to be driving a dark North American manufactured SUV on the Interstate 75 toward Chicago on August 15th. This is itinerary information usually only known to small groups of individuals and not the general public. The tip was sufficiently
But
corroborated.
counsel did assert that it needed to be reliable in the assertion of illegality. And on page 80 of the record, the tip says, "I write as a concerned citizen to let you know that there is likely to be a political attack soon. The Democratic Convention is in Chicago. It's at risk. Someone will be driving on the Interstate I-75 in North America in a North American-made SUV on this date. Car is dark-colored with Canadian plates. Driver is a white female. Doesn't speak English."
Your Honor,
So where's the illegality?
the illegality is related to the attack. This court held in United States versus Talley that they can take facts plus inferences. We know that there's going to be a political attack, which is likely to be violent, because at page 11 of the record, FBI headquarters had noted that previous political attacks included bombs, therefore it demonstrated sufficient indicia of reliability. Turning to that second point, in United States versus Washington, the Supreme Court held it does not offend the guarantees of the Fifth Amendment that a defendant is in the atmosphere conducive to truth-telling. Your Honor, I see that I'm out of time. May I briefly conclude?
Please.
Because the statements made by agents were not unlawful and were truthful, they were not the type of statements to render the confession involuntary. For these reasons, the United States respectfully requests that this court reverse. Thank you.
Thank you. All right, Counsel, Ms. George, 2 minutes rebuttal. You get 2 minutes? Okay, great. Thank you. All right, thank you very much. This court will be in recess. Thank you.
Thank you. All right. We will let you deliberate for a couple of minutes in the jury room. And relax. Okay. Okay, congratulations to our advocates. Let's give them another hand. They did a good job under tough questioning. While we wait for them to deliberate, I'm going to hold off and announce the best brief winners when the judges come back so that they can be recognized as well. I will say right now that oral advocacy is so important, and you all have done a wonderful job and represented us really well. Brief writing is also incredibly important. The written advocacy document is the thing that the judges have before they come and take the bench, and it's the thing they have afterwards. So after the memory of the stunning oral argument is gone, what we're left with is the brief. And so I think I would ask you to, when we get to the list of the best brief nominees, to really give a hand to those people for writing really excellent quality work and putting in tremendous effort. So the other thing I want to do right now is just give a shout out to our GLS faculty who teach in the Global Lawyering Skills Program. You have quite a few of your faculty here tonight. First of all, our excellent timekeeper, Professor Claxton. We also have Professor Erin O'Neill. Professor Dan Bernstein is here tonight. Professor Jacqueline Lloyd is here. Professor Haley Graves is here tonight. And I don't have my glasses on, but I don't think, did I miss anyone? Professors Noreen Evans, Rick Schickley, Bill Shapiro, and Ray Tamadin. I don't think we're able to make it with us, but let's give them a collective hand.
And don't forget Professor Moylan.
And I'm here. Thank you. It has actually been quite joyful to be back teaching GLS 3 this year. I will say that after the 5 years of associate deaning and no oral advocacy, it's been quite fun to have the experience again of getting to be in this classroom. So I also want to thank our teaching assistants. And Sabina is here, so give her. I don't think my TA is here. Sarah is not here, but she's awesome. Nick, is Nick here? Nick Klinkenberg? No? Okay, he should be. His sister was nominated. Come on. What is going on? Where is he? Okay, we've got a few people who we need to talk to. Okay, and then Emily. Is Emily here? No. Emily Savon? No. Okay. Well, we tried. Anyway, yay for our teaching assistants. How are they doing?
Still deliberating, I'm not gonna interrupt him.
No, okay. Well, at some point I will, but we'll give them a few more minutes. Okay. Well, pause, talk amongst yourselves. I'll be right back.
Weapons, forms, and consequences.
I'm gonna tweet that. You can sue. I don't see it at the reception. What reception? The one out here? No. Yeah, I'm like, and she's thinking.
The court is back in session. Please come to order.
Court is resuming. Oh, I have to get them. He can come down with you. Yeah, he can. Bring him down. Bring him down. He's going to be so much happier if he can come down. I'm sorry. Don't be sorry. Bring him down. Oh my gosh, I'll hold him if I need to. Everybody knows it's my weakness. Okay, our judges are back. I think you may all be seated. And we're going to announce first the winners of the brief awards. And I'm going to have them come down and shake hands with the judges on their excellent work. You don't have to get down, like just like this. Let me demonstrate. Okay. So first I'm going to read a list of all of the Best Brief nominees. So on the appellant side, we had, and as a reminder, this is one brief from each side from each section. We had 10 sections of GLS 3 this year. So there are 10 nominees for the best appellant's brief, and there are 10 nominees for the best appellee's brief, and we give 2 awards in each category. So there will be 2 winners on the appellant side and 2 on the appellee side, but everyone on this list is a winner because they got the best score in their class on the brief on their side. So everybody's a winner, okay? So our winners of the, like, I'm just reading them for you all. Katie Aristigui, Anna Azevedo, Amanda Carlson, David Edwards, Jordan Fortunati, Rosio Magallan, Jasmine Osmani, Michelle Ruffner, Abigail Tabora, and Michaela Thompson are the nominees. Give them a hand for the appellant. Okay, and for the appellees, the nominees are Avery Bernard, Roxanne Galdos, Kyle Hall, Alex Leahy, Rebecca Marr, Jack Morrison, Benna Nalapwa, always has been trouble, even though I had her last year, hard last name, but I did it. Okay, Christina Verona, Maxime Wagas, and Hadil Zidane. Okay, so on the appellant side, the best briefs are Michaela Thompson, whose brother should be here to see this.
Congratulations.
And Jordan Fortunati. Congratulations. Okay.
Congratulations, good job.
Congratulations, Jordan.
And on the appellee's side, we have Rebecca Marr, who I do not see here. Yay, Rebecca. And Jack Morrison. Here? No? Okay, maybe I'll give it to 2 other people. No, I'm just kidding. We'll give it to them. Okay, let's get a picture. Why don't you guys stand right here and get a picture with the judges here? Like, one of you here and one here. Okay, can we get that, Judy? How's that work? Can you see everybody?
Can you show us your certificates? Open it?
Is that a good setup?
Yeah, that's great.
Okay. Yeah, sorry.
3, 2, 1. Very lovely. Thank you.
Okay. Okay, and now the other thing I want to note is that every one of our top 4 advocates will be getting a certificate that I will be giving to you when we do the pictures for your excellent oral advocacy skills. I'm going to have the judges give you comments and announce the top oral advocate for 2024. And also, all of the top oral advocates will receive a Diana P. Scott Award, and all of the best brief winners receive an award as well. That comes not just the piece of paper, a little more. Okay, all right, over to you, judges.
All right, I guess I'll start off. We did have an opportunity to talk when we went back in our derobing room, and I'll say this, all 4 of you did outstanding job. It was very, very difficult to pick one out of the 4 of you because each of you did a fantastic job. It's very rare that attorneys who've been attorneys for years can stand before full-fledged judges on whatever level, Superior Court, federal judges, and, you know, if you've seen a picture of my photo, it's very rare that someone can look me in the eyes and not flinch. But I was impressed because all of you, your demeanor was perfect. You all looked us in the eye. You all were what I would say were ramrod straight, and you answered the questions. There were a few times, and just to make sure that I'm being even-handed and giving, you know, really good criticism. There were a couple of times there, for example, when I think I threw you for a loop a little bit, and then you kind of stopped a little bit. Then there was one time you said I was wrong. First of all, I'm never wrong. Okay? And second, no, just be more circumspect in how you phrase that with a judge. It's okay to point out to a judge that they're wrong, but just don't say it. There's a way you can tell the judge, perhaps, Your Honor, you didn't consider this, okay? And that's something that you kind of want to do. But other than that, now remember I said we're kind of nitpicking here because, quite frankly, you did fantastic. It's more difficult to represent that side than it is to represent the government side, because the government, you know, and that's true in life. I was a government attorney. I was a defense attorney as well. And the government has the evidence on their side, right? They do. And so that's difficult, but I thought you two did exceptionally well. And as for the government attorneys, I thought each of you did well. I thought you guys were just perfect. Your citations, all your citations were absolutely fantastic. I think what we looked at is to what extent that, you know, and I want to say someone went off script, but none of you went off script. It's just little things, just fine tuning little things. But I didn't have much in the way of criticism of either one of you. I thought you guys did a great job, but my colleagues may disagree, so I'm going to let them say a few words.
I want to say just quickly, it was fantastic. And I was sharing this with your professor and dean. 20 years ago, I was in your shoes sitting there, and I know exactly how stressful it is on top of preparing, not knowing what the judges are going to ask you, but you're also preparing for your classes that you're having at the same time. Your family is probably and friends are present in the room, and despite that, you were polished. And
she did win. She won.
So I want to just quickly just touch on each of you. Cassandra, I thought you knew your cites so well. You were able to cite to page numbers in the record. When I asked you questions about cases, it was succinct, easy to understand, and you were very concise. And you knew your script. You weren't going to get derailed with our questions. You were going to go back to the things that you thought were important for us to know. And when I asked you about the facts of the case, you knew it well. So great job. For Natalie, several things. You were able to distinguish cases when I asked about them. And that's not easy, because to know all of the cases that you have in your mind and know the facts and then be able to, in the moment, be able to answer my questions of what distinguishes that, you were able to do that. You referred to cases in your answer. Often judges are going to ask you, what's the legal authority for it? And if you can come back with legal authority, that makes you really persuasive for judges. I also thought that you were able to have a free-flowing discussion. You were able to move away from, you know, sort of your script, and you can multitask because I see you watching at the same time. So great job. I want to go over to Annalee. You were able to just cite to the record without losing a step. It was fantastic. I also wanted to say that there were times when you weren't citing to the record, but it was clear you knew the record front and back, and that more relaxed demeanor let me feel that you knew your record cold. And I also thought that in my notes I had that you had a good summary of the case facts and you were respectful to the court. And then Millie, I thought that you were, when you went back to opposing counsel's arguments that were made in the oral argument, that showed me that you could think on your feet, because you have a script and you keep to the script, but that showed me that you were thinking and listening while the arguments were happening. Oftentimes, counsel are so focused on their own argument, they're not listening to what's happening in the moment, and that showed me that you did. You also had a really relaxed demeanor that made it easy for me to understand what you had to say. And I also thought that you were able to distinguish other cases very well. Great job.
Okay, so let me go ahead and start with, I am a family law Superior Court judge, so I don't hear a lot of appellate arguments, but in practice, I was at the Attorney General's office for about 18 and a half years and did an extensive amount of appellate argument. So I understand being in your shoes, and all of you did such an excellent job. And I'm not sure how you're going to hear our comments because you're probably on an adrenaline high, right? So, but let me suffice it to say that you were very, very good and solid and persuasive in your arguments. All four of you had an excellent handle of the record and of the case law. And so let me go, I'll go point by point. All of you had excellent eye contact and an introduction, but Cassandra, you were first out of the gate, and man, you got up there and you were sharp and you were like a machine, right? So the one comment I will have, and this goes for all four of you, is when you have that eye contact, which was superb, you can also break it. It's not a staring contest, right? So there are three justices up here. You can go ahead and look for a moment, look to another justice. Even if one justice asked you a direct question, the answer could be posed to all three of us, okay? All right, so excellent eye contact, Cassandra. I really enjoyed hearing your theme. You being first out of the gate, you set the bar high. And the other thing I would say, so there's a style. You're all gonna have your own style when you are out in practice. I have here as a comment for Cassandra, you did not miss a beat. When somebody asked you about the facts, I think it was Judge Coggins asked you about the facts of Reyes, you did not miss a beat. You just went, bam, yes, Your Honor, the facts of Reyes are da-da-da-da-da, and you just rattled it off. So excellent. You had a question about objective standard, and you answered that really, really well. Natalie, another, again, really good presence, really good eye contact, and excellent theme in the beginning. You had an excellent handle of the record and of the case law. I thought you were going to get tripped up when you got posed the question, why do you assume that somebody who's college educated is not going to be coerced? You paused for a split second and then you rolled out your answer very smoothly and in an extremely responsive way. So well done there. And then I have here, both of you had an excellent handle of the record. All right. So Annalee, I liked your style. Okay, I thought you were more conversational in your style. That's sort of my own style as well. I'm a little more conversational than I am scripted. I thought your knowledge of the record was excellent as well. You had a question about testimonial questioning, and I have here excellent answer to the question. I thought that was one of your most persuasive points when you said the agents elicited testimonial interrogation, and that went too far. I thought that was extremely persuasive, so well done there. And then you had a question about good cop, bad cop, and all of you did this really well, transitioning. You're like, you know what, justices, we need to move on. Moving to my next point, all of you did that really well. I noted it in yours, but I did also see it with everybody. Millie, same thing, good eye contact. I liked that all four of you did your, here's what I'm going to talk about, and here are my 2 points. I thought there were going to be 3, but really with 10 minutes, you really only have time for 2. Excellent job outlining and headlining for the court, so we could follow where are we in terms of the topics. All of you did an excellent job there. I asked you, Millie, for a pinpoint cite to the record, right? Because you made a comment about that the agent said that they would not allow X unless she gave a confession. I thought it wasn't, they didn't force a confession. They said, until you answer our questions, but you did not miss a heartbeat. You said, Your Honor, at page 68 of the record, and I looked it up, I'm like, well, there it is, she was right. So excellent handle of the record. Again, good transitions, very strong argument on reliable in the assertion of illegality, and to the point where I raised it during rebuttal. And you had an excellent response in rebuttal. Rebuttal is tough. because, you've got to pivot, you need to pivot really quickly. You only had 2 minutes and you had 2 questions. So you had to make a strategy call. Am I going to make 2 points or am I going to make 1? You know what I mean? So I think, I know both of you ran out of time and it was because we had a hot bench. But Mr. Schwartz said that was good, so, right? So anyway, really, really, I'm just very impressed. Congratulations to you all. Excellent job.
Oh, we have to pick a winner?
And the winner,
Oh, okay. Well, the winner is Natalie Parker.
here's your certificate. Why don't you all come down and we'll do photos and.
And we didn't know you had a child in the audience either.
That's right. We had
No.
But we know now.
You by your lonesome.
First by her lonesome, and then we're gonna get everybody in with her. Oh, no, I mean
wait, with you
judges.
judges.
With the judges.
You guys are more important.
There you go.
Sure. Thank you. 3, 2, 1. Let's do one a little closer. 3, 2, 1.
Okay, and now, can we get the other top out? Is this judges stay in?
Oh, okay.
Yeah, stay in and everybody show your certificate and, yeah, show your certificate, I think. That's-
Yeah, how about you in the middle? There you go.
There we go. Can you get them all, Judy?
I did, yeah. Bring the angle a little bit this way. All right, 3, 2, 1. 3, 2, 1. Okay, perfect.
Okay, great. Okay, so now everyone is invited over to the Grand Salon for a reception. Yay, see you over there.